All right, good morning, everyone. It's December 17th, 2020, and this is our commission meeting. We'll go ahead and get started with the roll. Ms. Linker.
Commissioner Cardenas.
Here.
Commissioner Hatch. Commissioner Wilson.
Here.
Chair Matich.
Here. Good morning, everyone. I wanted to begin with an important announcement. This week, we received notice from the State Controller's Office that she has appointed former Assembly Member Catherine Baker to the Commission. Former Assembly Member Baker will begin on the Commission in January. She is replacing Commissioner Hayward due to her resignation a couple months back. So we look forward to incoming Commissioner Baker joining us next month. Moving to item number 1, public comment for items not on the agenda. Do we have any telephonic or digital public comment for items not on the agenda? All right. Hearing and seeing none, we'll proceed to item number 2, approval of the November 2020 Commission hearing meeting minutes. Commissioner Cardenas, Commissioner Wilson, do either of you have any edits or comments for our meeting minutes?
Not for me, Mr. Chair.
No. No, Mr. Chair.
Thank you. Do we have any public comment on the meeting minutes? Hearing and seeing none, do we have a motion to approve?
So moved.
And I'll second. Ms. Linker?
Commissioner Cardenas.
Yes.
Commissioner Wilson.
Aye.
Chair Matich.
Aye.
The motion passes.
Moving to our enforcement consent calendar, these are items 3 and 4 on today's agenda. Do any commissioners wish to pull any of the enforcement consent items for separate discussion?
No, Chair Matich.
All right. Do either commissioners have any questions or comments for Chief of Enforcement Brereton on either matter? Hearing
No.
and seeing none. Do we have any public comment on our enforcement consent calendar? This is items 3 and 4 on today's agenda. Hearing and seeing none. Do we have a motion?
So moved.
Second.
Ms. Linker?
Commissioner Cardenas.
Yes.
Commissioner Wilson.
Aye.
Chair Matich.
Aye.
The motion passes.
Thank you. We'll proceed now to item number 5. This is our notice of intent to present a default decision and order at the January 2020 Commission meeting. And this is in the matter of Friends of Long Beach City College, yes on Measure LB, and Lexi Donovan. Do commissioners have any questions or comments on item number 5?
Chair Matich, I do have a question. It's more for the benefit of just transparency in terms of the process. But if the Chief of Enforcement could explain what is the basic process that results in a default judgment such as the one that's on the agenda?
Certainly. Angela Brereton, Chief of Enforcement. We try to settle most of our cases. And so that involves cooperation with the other parties. The way we get to a default is that we usually don't have cooperation from the other side. So we get to a point in our proceedings where we will first issue a probable cause report. And often you'll see in these defaults that we don't receive any response to the probable cause report. And so then we proceed with an ex parte and request a finding from the hearing officer, which is uncontested. So it's just based on the report. Then we will, the hearing officer also included in that order allows us to file an accusation in the matter. So we file and serve our accusation. The accusations are personally served. And again, in order to get to the default, the respondents do not issue a response to the accusation. In an administrative hearing, that's called a notice of defense. And so when they don't participate and don't file a notice of defense, then we move forward with the accusation. Now, we usually try to, reach out multiple times throughout this process to make sure that they are getting the information, that we have the valid address, with personal service, we know that they've been served. So, it does take a lot of effort to get to the point of the default. But we do continue to try to engage them in the process throughout that time.
Okay, well, that's very helpful. That's the summation that I kind of anticipated, and want to commend you and your staff for your due diligence. Now, in this particular case, are there adequate funds in the campaign account to pay for the fine, or potentially would some of the parties have to pay out of their own personal funds?
For this particular matter, the committee has terminated, so it does not have any funds available for the committee. So the parties that are personally named would be liable. Now, I would like to add, one of the pieces that we have implemented at the commission's request was to start pre-noticing defaults. Basically giving a one last chance, like, here you go, we're going to be presenting this. And in this particular case, we received a response from the parties. So hopefully we can reach a resolution that is not a default, because we would prefer to have the parties involved and not, have to go through the default process. So I don't know the time frame yet on that, if you'll see something on next month's agenda or if it'll be a month or two out. But that is good news for this particular matter.
Okay. That was very helpful and an excellent summary. Thank you.
You're welcome.
Thank you, Ms. Brereton. I'd like to just pause for a moment, allow the record to reflect that Commissioner Hatch has joined us. Good morning, Commissioner Hatch. We are on item number 5. Did you have any comments or questions on item number 5, Commissioner Hatch?
No, I don't. Thank you.
All right. Is there any public comment on item number 5? Hearing and seeing none, we look forward to your update at a future commission meeting, Ms. Brereton. Thank you very much.
Thank you.
We'll go ahead and move now to item number 6. These are general items. Updates to lobbying campaign and slate mailer forms. Today we have Dr. Jadell, our manager from the education program in the legal division, to present. Good morning, Dr. Jadell.
Good morning, Chair Matich and Commissioners. We present for your approval campaign forms, slate mailer forms, and lobbying forms. Staff also recommends your approval of the elimination of forms 462 and T10. Revisions were made to the instructions and content of these forms in order to incorporate needed changes resulting from legislation that will go into effect early next year, SB 1239 and AB 909. Proposed changes are required in order to implement the Secretary of State's Cal Access Replacement System, CARS project. The changes will be effective when CARS goes live next year. Additionally, new instructions were added to forms related to recently adopted Limited Liability Company Regulations 18402.2 and 18421.10. Form 462, the independent expenditure verification, is being eliminated as the independent expenditure verification information will be captured directly on the forms 450, 460, 461, and 496 once CARS goes live. The T10, committees primarily formed for state ballot measures or candidate top 10 contributor list, is being eliminated as that information that it collects will be collected by the new CARS system when filers file campaign forms online or electronically. The draft forms were made available on the Commission's website for a 30-day interested persons comment period in November. Please note that proposed changes are highlighted in yellow on the forms, and changes made as a result of public comment are highlighted in green. Highlights, strikeouts, and other editing notes will be deleted in the final versions. Staff recommends your approval of the updates. Thank you so much.
Thank you, Dr. Jadel. Can you clarify for us? I understand from the memo on item 6 that these changes will be effective when CARS goes live next year. Is there a date certain when CARS is going to go live?
My understanding is that there's not a certain date. Possibly Ms. Brar can comment on that. I know that they hope for the end of February.
Yes, that is their target date, February 28th, 2021. That's what we've been told.
And will CARS be turned on in its entirety on that date, or is it going to be a rolling implementation?
I think that most of it will be live on that date. There is some aspect that may be rolling. That's what we've been told. I'm not exactly sure of the details of exactly what will be rolling, but I know that most of it will be live that day. Or that's the plan anyway.
All right. Well, to the extent that we have any changes that are tied to the implementation of CARS and a portion of CARS doesn't go live on the target date, I assume we're going to be communicating that to folks so it's very clear which changes are in effect on day one and which may be implemented on a future date.
Yes, we will.
All right, very good. Thank you both. Commissioners, questions or comments for staff on this item? Do we have any public comment on item number 6? Hearing and seeing none, do we have a motion to approve?
Dr. Jai, terrific summary. I move to approve.
Second.
Ms. Linker?
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Wilson?
Aye.
Chair Matich?
Aye.
The motion passes.
Thank you. Thank you, Dr. Jadel, and thank you, Ms. Brar. Appreciate your work on this.
Thank you so much.
Commissioner Matich?
Yes.
We've been having trouble with the public comment line, so we may want to keep it open a little bit extra to make sure we haven't missed any public comment.
Thank you. We'll be doing that. We'll circle back to public comment towards the end of the meeting. We'll now proceed to item number 7. This is pre-notice discussion of regulations concerning campaign contribution limits. We have our general counsel, Mr. Bainbridge, and also who assisted on this but is not with us this morning, Caitlin Green, one of our commission counsel. So good morning, Mr. Bainbridge.
Good morning, Dave Bainbridge, General Counsel, filling in for Ms. Green, who had a baby boy 6 weeks ago. So she'll hopefully be back when it's time for adoption of these regs, but I will try to handle the pre-notice portion of it. These regulations came about as a result of AB 571. To refresh your recollection, that's the bill that applied the state limits to the city council and county supervisor offices elections if the local jurisdiction doesn't have a limit of its own. So the state limits will now apply to those offices if they don't adopt their own limit. The state limits came about back in 2000 as a result of Prop 34, which was a wide sweeping initiative that brought in contribution limits that applied to state candidates. So these will now apply those same laws, same statutes that came about with Prop 34 to the local officials that I discussed earlier. As part of that process back in 2000, 2001, as a result of Prop 34, the commission went through an extensive regulation adoption process. If you don't believe me, go back and look at some of the agendas. There's many regs for many months adopting and implementing the new contribution limit process. A lot of what the regulations do is implement the intent and the language of Prop 34 and then integrate how that will operate within the act from a practical standpoint. They were aimed at making sure that these limits were workable and effective and that there were proper rules in place so that the rules put in place by the initiative could be enforced and frankly followed and understood by the people that had to comply with the contribution limits. So over the last 20 years or so, we've refined these regulations as we've gone along, as we've seen issues that needed to be addressed. At this point, I think they're pretty good. They're pretty effective. So I mention all this to make the point that what we've now done is take the regulations that we've had in place for a number of years and apply them to the offices, the city and county offices that will now be subject to the jurisdiction of the FPPC because they haven't adopted their own contribution limits at the local level. So the regs in general, it's a long list, so I don't plan to go through each of them in detail, but I'll take any questions. In general, what they do is apply the same rule that's been applied to state candidates for years in terms of contribution limits and apply those to those city and county offices that are subject to AB 571. We believe this approach is consistent with the legislative intent to apply the state rules in their entirety to these local offices that haven't adopted their own contribution limits. I would point out that locals always have the option of opting out of these limits that are applied by AB 571 and enforcement by us, and consequently these regulations as we propose them by adopting their own limits and their own schema for enforcing contribution limits. The memo provides a summary of the purpose of each regulation. We're not changing those. We're simply applying what the good folks that came up with these rules back in 2001 at the commission, and as we've gone along over the years, implemented. So essentially, we're just adding in most places these city and county offices that are now subject to the state's contribution limits. With that, I'll open it up for any questions or comments.
Thank you, Mr. Bainbridge. Do commissioners have any questions? Commissioner Hatch, I see you have a comment.
Thank you, Mr. Chairman. Mr. Bainbridge, do we have any idea how many agencies are exempt under the terms of the legislation? And also, I should know this, but I can't recall, are the agencies that are exempt only exempt as to the offices that they have limits, local limits applied, and subject to this provision if they have not?
To your first question, we don't know. I haven't seen those numbers, and I think many of the local jurisdictions are currently going through the process of figuring out if they want to adopt their own limits or use the default state limits. So I think that's going to be a moving target here over the next few months. I read an article every couple of weeks about a jurisdiction considering what to do about their own limits. So if at some point we have numbers on those, once it's kind of settled down, we can report those back. And then, sorry, what was your second question again?
Thank you. My second question, I'll try to make it clear. If, say, a county board of supervisors has subjected themselves to a local limit, but they haven't adopted a local limit, say, as to the controller and the registrar of voters and so on, are they subject to our jurisdiction as to those offices that they have not established a limit?
Yes, that's correct. It's just when they establish a limit for the office.
So it's by office?
Correct.
Thank you.
Do other commissioners have questions or comments for Mr. Bainbridge on this pre-notice item? All right, hearing and seeing none. Do we have any public comment on item number 7?
Hello, can anyone hear me?
Yes.
Okay, I was just testing the line.
All right, apparently that was one of our IT staff testing the line, so we've now confirmed the line is working. That's great. Do we have any member of the public who wishes to make public comment on item number 7 at this time? All right, hearing and seeing none, this item will return to us. Mr. Bainbridge, is this coming back in February then?
Yeah, that's correct, February.
All right, we look forward to this item returning in February. All right, we'll now go ahead and proceed to item number 8. This is adoption of amendment to regulation 18351. Continuing with us, Mr. Bainbridge, and also Ms. Brar, our Assistant Chief Counsel from the Legal Division, and also Torrin Lewis, our Commission Counsel. Welcome, everyone.
Thank you, Mr. Chairman. As mentioned, Torrin Lewis, Commission Counsel with the Legal Division. I'm going to be presenting proposed amendments to Regulation 18351, which are updates to the Commission's Conflict of Interest Code. The Act requires that every agency adopt a Conflict of Interest Code and designate positions within that agency other than those accepted by Section 87-200, which involve the making or participation in the making of decisions that could foreseeably have a material effect on any financial interest. Secondly, the Act provides that positions shall be identified to identify those interests of the designated employees that are reportable. So to this end, each state agency must amend its Conflict of Interest Code when it creates new job classifications, revises job titles, deletes positions, or alters the scope of job duties for designated employees. The Commission's Conflict of Interest Code specifically is found in Regulation 18351, which was last amended in 2017. Broadly speaking, the current proposed amendments before you today include adding new positions, reflecting title changes to existing job classifications, eliminating job classifications that no longer exist or which are no longer making or participating in governmental decisions, and finally, revising disclosure categories for existing job classifications whose duties have changed. This draft code was presented to the Commission for preliminary approval at the June 18th meeting this year, and the specifics of these changes are outlined in the regulation memo, which you should have before you. But of course, I'm happy to answer any questions about the specifics, should the Commission have any. In terms of process and timeline, if the Commission chooses to approve these changes today, they will go to the Attorney General's office. Once again, we have received preliminary approval from the AG's office in August, and subsequently staff filed the OAL notice and began the 45-day notice period, in addition to sending notice to all affected staff, both via email and providing notice via our staff intranet on October 9th of this year. Beyond that, each affected staff member was also notified by their supervisor as well. And so, again, if the Commission chooses to approve the code as proposed today, the changes to the code, it will need to go back to the AG's office for final approval and then be filed with OAL, upon which OAL will send to SOS for endorsement the code, and it will be effective 30 days from that endorsement date. So with that concludes my basic overview, but I'm happy to answer any questions about the details.
Thank you, Mr. Lewis. Do commissioners have questions or comments for Mr. Lewis? All right, I have a question for you, Mr. Lewis. It just occurred to me. I know you brought this to us a couple months ago for the first time, but so we have abolished the prior position of Legislative and External Affairs Coordinator, and we've replaced that with a Legislative Counsel. So my question is, between now, assuming we approve this today, and the time we receive notice from OAL and the AG, et cetera, is our Legislative Counsel subject to the Conflict of Interest Code?
That's a great question. I know what we have discussed is that all affected staff, existing positions, would file their SEIs as per usual up until the date of their 2021 SEI period commencing. I would have to defer to Suki and Dave as to that question.
Yeah, so the Legislative Council would file under full disclosure, which would be the same as what they would be when the code is effective. until the code is effective. So the really now should be filing under full disclosure and still would be once the code is in effect.
Okay, that's great. That was really sort of at the heart of what my concern is. It sounds like we're really just making sure the paperwork's catching up with what we're already doing. That's great. All right. If other commissioners don't have questions or comments, I'd open it up for public comment on item number 8. Hearing and seeing none, do we have a motion on item number 8?
So moved.
Second.
All right, motion and a second. Ms. Linker?
Commissioner Cardenas?
Yes.
Commissioner Hatch?
I believe Commissioner Hatch is saying aye. I can read his lips.
Commissioner Wilson?
Thank you, Commissioner Hatch.
Aye.
Chair Matich?
Aye.
The motion passes.
Thank you, everyone. And thank you to staff for your great work on this. Good job, guys. All right, we'll now move to item number 9. These are regulation projects and schedules for 2021. Today we have our Executive Director, Galena West, and General Counsel, Dave Bainbridge. Welcome back, Mr. Bainbridge and Ms. West.
Thank you. I'll give a brief presentation. I can't believe it's already been a year, but we're back again with the reg calendar for 2021. To refresh people's memory, this is what we put forth with the reg calendar is a general plan for the year in terms of what regulations we're going to have the commission consider. It is a draft. It can change and does change over time. But our intent with this is to get the information out there, have a general plan in place. We follow it as much as we can, as much as will work out. But the real goal with this is to give the public an idea of what the commission plans to consider over the next year, or 9 months, as this one kind of tails off towards the end of the year to allow time for additional projects. So this way, if there's interest from the public or even internal staff or specific commissioners, they'll have an idea of when regulations are coming up. The hope is the earlier we get participation, the better product that will come out of it, and the less late nights right before a commission deadline where we're drafting or revising regulations. So I won't go into each project, but I'm happy to answer any questions. The projects are generated based on staff recommendations, commissioner recommendations, items that maybe we didn't get to yet this year. A number of these projects are already underway, as you'll notice, especially the ones early on in the year. So if there are comments, questions, suggestions, happy to take them now.
Great. Thank you, Mr. Bainbridge. Questions or comments from the commissioners on a regulation calendar and schedule for next year? All right. Hearing and seeing nothing from the commissioners, do we have any public comment on item number 9? All right. Hearing and seeing none, do we have a motion to approve the regulation projects and schedule for 2021 as proposed?
I move for adoption.
Second.
Ms. Linker?
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Wilson?
Aye.
Chair Matich?
Aye.
The motion passes.
All right. Thank you, everyone. Thank you, Mr. Bainbridge. Thank you, Ms. West, for your work on this project. All right, this time, before we move on to item number 10, I'm told that we had some IT issues with our public comment line early in the meeting, and so we'll now go back to item number 1, public comment for items not on the agenda. Is there any public comment for items not on the agenda? All right. We'll go ahead and proceed then to item number 10. These are committee updates. We had 2 meetings in December, our Law and Policy Committee, which is Commissioner Cardenas and I, and our Public Outreach and Technology Committee, which is Commissioner Wilson and myself. Starting first with law and policy, we discussed 3 matters. The first is an item that is on today's agenda. It's item number 11, our commissioner compensation policy. So we'll get into that with item 11, but Commissioner Cardenas and I heard from staff on various options for modifying our commissioner compensation policy, and we'll be recommending something to the commission on item number 11. With respect to, we held interested persons feedback on our pre-noticed amendments to regulations governing enforcement division streamline and warning letter programs. We heard from Ms. West and presented some recent changes to that proposal and received public comment on that item as well. And finally, we heard a legislative update from our legislative counsel, Ms. Nakano, after which we discussed what we would be hearing in January of 2021 through our committee. And the only item currently scheduled to come before the Law and Policy Committee next month would be a legislative update at this time. So, Commissioner Cardenas, did you have anything to add to that summary of what we did in Law and Policy?
No, that squares with my notes and my recollection. A very good meeting.
Great, thank you. Commissioner Wilson and I, as I mentioned, also had our Public Outreach and Technology Committee meeting. I thought that was it was a great, primarily revolved around receiving information from staff on how staff does outreach regarding changes to our regulations. Commissioner Wilson and I were able to provide some feedback and some suggestions on ways we might be able to improve that, but also understand what staff is currently doing. Commissioner Wilson, was there anything in particular that you wanted to point out from that meeting?
No, Chair Matich, you provided an excellent summary. Thank you.
All right, thank you. All right, now moving on to item number 11. This is our commissioner compensation policy. And under this item, we'll consider making a change to our current policy. Specifically, at Law and Policy, Commissioner Cardenas and I are recommending that we delegate authority to amend our existing compensation policy adopted in February of 2018 and update that accordingly. So Commissioner Cardenas, I don't know if you would like to sort of take the lead on this and talk about what's motivating this and what the proposal is that we would like to recommend.
Sure, Mr. Chair, thanks very much. Members, I have been long concerned about the efficacy and the ethics involved in commissioners establishing their own compensation policy, and it's not a concern that is specific to our commission as currently or otherwise constituted. It's just a general concern about any public body, legislative or appointed, that would seek to have a direct say on its own income stream, whether it's de minimis, as in our case, or establishing annual salaries, or anything in between. But particularly because we are, of course, who we are, and we are charged with adhering to, administering, and advancing the letter and the spirit of the People's Political Reform Act. It seems to me that it's not appropriate whatsoever for us to have any role in the setting or alteration of the so-called compensation policy. And so to liberate future commissions from the appearance of not being objective and passionately disinterested, if you will. We heard from Mr. Bainbridge several options that perhaps he might be in a position to go over right now. But the thinking is that perhaps we are all better served, as would be the public, that we delegate, that the commission delegate the authority to establish or alter in any way a commission compensation policy to the chair. And this strikes me as appropriate for a couple of reasons. First of all, the chair is the chair is the chair. And particularly when one looks at the Political Reform Act, the chair is the only full-time salaried member The chair is round the clock, particularly this chair, with respect to the responsibilities that are before the commission and the responsibilities that that weigh on the chair. And I think the chair is in a position to understand the work that's involved, how things are going, and what might constitute an appropriate alteration to an existing compensation policy. The chair, as the chair, understands the work that the rest of the commissioners are doing, and the chair understands the need to maintain the appearance as well as the reality that our commission, in particular in this state, always establish a high floor and an aspirational ceiling when it comes to how we undertake our responsibilities. And so I personally feel comfortable that that everyone is better served by delegating this authority to our chair and to empower him with this delegated authority to seek comment from the public, including perhaps past commissioners, academics who specialize in the area of ethics and political ethics, and weigh all of this input, such as it may be, and then arrive at a determination that she or he considers to be in the best interest of the commission, given its charge. And so, I don't know if Mr. Bainbridge is in a position to offer any further commentary beyond what my dog is offering in the background, but I believe that we should delegate this authority to the chair, and future commissioners should not labor under the responsibility of giving the appearance, at least, that we are more interested in our pockets than we are with doing the people's will. Thank you, Mr. Chair.
Thank you, Commissioner Cardenas. Mr. Bainbridge, do you have a draft proposal that you could recite to the other commissioners to sort of put a fine point on what Commissioner Cardenas was just describing?
Sure, and to clarify for the commissioners that weren't at the law and policy meeting, the different options that Commissioner Cardenas referred to, one involved essentially creating an advisory committee to both involve delegating the authority to come up with the policy to disinterested parties. One option would be to create an advisory committee to do that. And then the other had been to simply delegate the authority to the chair to make that determination. What the law and policy committee decided to recommend was the second option. So if you'd like, I can recite the motion that I guess I'll be saying it on behalf of Commissioner Cardenas, I think, is how this is going to work. And if he disagrees with any part of it, he can stop me.
Thank you, Mr. Bainbridge.
Sure. I move the commission hereby delegates to the chair the power to revise the commissioner compensation policy after soliciting public comment from interested persons, including former commissioners and governmental ethics experts. Upon completion, the chair will provide a copy of the updated policy to each commissioner, and the policy will be posted on the commission's website. Any public comment received by the chair related to the policy will be made public.
Thank you, Mr. Bainbridge. Do commissioners have questions or comments for Mr. Bainbridge on the proposed policy? Commissioner Wilson.
Yes, thank you for the excellent summary, and commend the chair and Commissioner Cardenas and Council Bainbridge on their hard work in this area. Just for clarification, and I already know the answer to this, but it's my understanding that by delegating it to the chair, that would not impact the chair's compensation, because the chair's compensation is, based on my understanding, established by statute. Is that correct, Mr. Bainbridge?
Yes, that's correct.
Okay, thank you.
Just a different statute from the other commissioners. Both are established by statute, but his is a different statute.
Well, correct.
Is there any further questions or comments from commissioners for Mr. Bainbridge or Commissioner Cardenas based on the motion? Hearing and seeing none, do we have any public comment on this item? Hearing and seeing none, do we have, Commissioner Hatch?
Sorry, I was reflecting. Is the process you described, is that a public process? In other words, after consulting, or does recommendations of these past commissioners and experts done in a public forum, and then the chair then pronounces that these are adopted, or is this done aside or off public?
Well, Commissioner Cardenas, my understanding is that the delegation will be for the chair to reach out to the group of experts articulated in the motion, including former commissioners, receive their input, and then propose a policy, adopt a policy, express that policy to the full commission and at a public meeting. And if the commission ultimately was dissatisfied with what a chair did in the future, the commission always reserves the ability to go back and redo the regs. But no, I mean, to answer your question, this wouldn't be taking place at a public meeting. I think this is the type of thing that I think for efficiency's sake, the chair and the executive director would be doing in the ordinary course, and then reporting to the commission after the fact.
I see. Okay, thank you.
Yeah, my understanding squares with what the chair just laid out, and I failed to mention that in the Law and Policy Committee last week, we did talk about the reservation on the part of the commission to always be in a position to vote otherwise. And so if a future commission were to be at odds with the chair's determination, then by a simple majority vote, the commission could, in the light of day, explain to all parties why it is that they feel that the compensation needs to be other than the duly delegated authority to the chair determined it to be following consultation.
Commissioner Hatch?
Mr. Chair, and Mr. Cardenas, I'm not quibbling with the decision that you're proposing. I'm just trying to clarify how it would proceed. In other words, as I now understand it, the deliberations would be in private, but the announcement would be at a public meeting of the action of the chair relative to any changes in the future, correct?
That's my understanding, yes.
Thank you. No more questions.
Great. Thank you. If there are no more questions, do we have a motion?
I move adoption.
Mr. Chair, I'd like the record to reflect that I move in precise accordance with the motion as articulated by our Chief Counsel.
All right. Thank you, Commissioner Cardenas.
Second
by Commissioner Hatch. Ms. Linker?
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Wilson?
Aye.
Chair Matich?
Aye.
The motion passes.
Thank you. Now proceed to item number 12. This is our legislative update, and we will be joined by our legislative counsel, Ms. Nakano. Good morning, Ms. Nakano.
Good morning, Mr. Chair and Commissioners. The legislature convened for organizational session on December 7th and has adjourned until January 4th. 4 PRA-related bills have been introduced so far. They were introduced after our agenda posting deadline for this meeting, so those bills will appear on the legislation memo starting next month. But today I'll give a short description of each bill. AB 20 was introduced by Assembly members Lee and Kalra. The bill would prohibit a candidate for elective office from receiving a contribution from a business entity, prohibit a business entity from making that contribution. The bill would additionally state the intent of the legislature to enact legislation relating to a public financing system for elections in the state. AB 40 was introduced by Assembly Member Lorena Gonzalez. The bill would impose additional disclosure requirements for slate mailers. To refresh your memory, a slate mailer is defined in the Act as a mass mailing that supports or opposes a total of 4 or more candidates or ballot measures. The additional requirements would include disclosing the number of members who make up the slate mailer organization or committee, and the total amounts paid by a candidate or ballot measure to appear on the slate mailer. The bill would also make some changes relating to required font size for certain disclosures. SB 78 was introduced by Senator Nielsen and also relates to slate mailer disclosures. It's very similar to AB 40 with some differences relating to font size. SB 79, also introduced by Senator Nielsen, is a PRA-related spot bill. Outside of that, staff is continuing to develop the proposal ideas previously approved by the Commission and to engage interested parties and potential authors. Also, the legislative calendars for 2021 have been set, and those are available on the Senate and Assembly websites.
Great. Thank you, Ms. Nakano. Do commissioners have any questions for Ms. Nakano? Commissioner Cardenas.
Yes, Mr. Chair, thank you. Ms. Nakano, thank you very much. First question, have the committees whose jurisdiction pertains to the commission's work been established beyond chairs?
Nope, committee assignments have not yet been set.
Have committee chairs been established?
Not to my knowledge.
Okay. And also my other question, Ms. Nakano, the first bill, I forget the number that you mentioned. It sounded at the end of your description of that bill that there's an open-ended, there's a possibility that it could be a campaign finance bill just generally. Is there a suggestion that there is that the authors are contemplating proposing a new publicly financed campaign finance regime in the state?
That's correct. The bill in print includes the substantive piece about business entity contributions, but also additionally has that piece, the intent piece, to create a public financing system for elections in the state. So it's only an intent piece at the moment, but it does convey that they are looking to expand that in future amendments.
Fascinating. I'm sure you will stay close to that one and keep the commission apprised as appropriate.
Absolutely.
Thank you very much.
Do other commissioners have questions or comments for Ms. Nakano? Well, I actually have a follow-up question now that Commissioner Cardenas asked about the public financing piece of it. Ms. Nakano or Mr. Bainbridge, if you're still on the line, I seem to remember that there was some restriction in our state constitution on public funding of campaigns. Is that a correct recollection? Do you know?
I believe there was a 2016 bill, and Mr. Bainbridge may recall this better than I do, that went to public financing. So we will be looking closely to see whether the issues that came up with that bill are repeated here.
Okay. Yeah, that's really my point. Is I would want us to receive some information on if there would need to be a constitutional amendment in order to implement that idea under these circumstances versus a simple statutory change. All right. Thank you, Ms. Nakano. Appreciate it. We'll now move on to item 13. These are our executive staff reports, beginning with Chief of Enforcement, Ms. Brereton.
My report is as submitted. Thank you very much.
Right. Thank you. Do commissioners have questions or comments for Ms. Brereton? Hearing and seeing none, I will just observe. I think you're doing a great job, Ms. Brereton. Keep it up.
Thank you, will do.
Yes. All right, let's go ahead and move to legal division. Mr. Bainbridge.
Good morning, Dave Bainbridge again. You guys are really taking it easy on Angela in her first couple of meetings. I will follow suit, except I have one addition to make to our report. The first item in our pending litigation section mentions that we had a hearing scheduled in the CSAC v. FPPC case. At the time of publishing this report, we hadn't had the hearing and hadn't had a decision. We have since got a decision from the court. The court in that case denied the petition of the California State Association of Counties and the California School Board. The petition was challenging the commission's regulations governing the reporting by public entities of the expenditure of public funds for campaign purposes. The court upheld the commission's regulations and found no grounds to strike any of the regulations that are in place currently. So just wanted to give an update on that report. Other than that, it's as submitted.
Thank you, Mr. Bainbridge. And on that note, with respect to the case you just mentioned, I'd offer my thanks and congratulations to the Deputy Attorney General who represented us in that case. Seth Goldstein did a great job, and internally, John Fazer in our office acting as a liaison, as well as yourself, Mr. Bainbridge. So thank you to everyone who participated in representing the commission in that case. Certainly an important issue for us. Other commissioners have questions or comments for Mr. Bainbridge? All right, moving on to our Administration and Technology Division then. Chief of Administration Hahn, good morning.
Morning, Chair and Commissioner. My report is submitted. This is.
Thank you, Ms. Hahn. Question for you. I know we've been, over the last several meetings, reporting on the outstanding number of SEI filers who still, despite our extension of the deadline, have not come into compliance. I think we started at 400 some odd. I think we were down to 300 last month. Where do we stand today, Ms. Hahn?
We are in the low 200s right now, so we're making improvement.
All right, good. That's all we can hope for. Do other commissioners have questions or comments for Ms. Hahn?
Ms. Hahn, just a welcome to your newest staff member. I understand, Ms. Davis. Welcome aboard.
Thank you.
Commissioner Wilson, did you have a nope? All right, Ms. Hahn, thank you very much. Appreciate it.
Thank you.
And last but not least, our Executive Director update, Ms. West. Welcome back.
Good morning, everybody. My report is even easier because I get to punt to our terrific press director, Jay Waimenga, to show us what our PSA looked like at the request of Commissioner Cardenas. Take it away, Jay.
Thank you, Galena. Chair Matich, commissioners, good morning. At a prior commission meeting, I believe Commissioner Cardenas had requested we replay these publicly. Again, to refresh everyone's memory, we created these before the spring primary election and had a limited run then. During the fall election campaign, we had a more significant PSA campaign effort, which reached ultimately, as I reported earlier, about 600,000 individuals across the state with about 1.5 million impressions. So I think we really got some pretty good bang for our buck with this. And so with that, I think IT is ready to play both our Spanish version and our English version of the PSA.
Want to know who's behind these ads? We're the FPPC, and we can help you find out.
¿Quieres saber quién está detrás de estos anuncios? Somos el FPPC y podemos ayudarlo a descubrirlo.
Well, thank you, folks. And again, a shout out to our own staff, IT, helping put this together, and our own Patricia Ballantyne, who did the voice for the Spanish language version. Talking with Galena, we are looking forward to doing more of these. Obviously, these we now have in hand, and we can use them again next election cycle. And we'll be looking forward to creating more of these and also reaching back to our local ethics agencies. We had been in discussion a couple of years ago, especially with San Diego and Oakland. We're very interested in coming up with some sort of generic evergreen type videos on the general topics of things like political ad disclosure, conflict of interest with public officials. So that will be one of my office's efforts in the new year. With that, thanks to everyone involved.
Great job, Jay.
Thank you.
All right. Thank you, Mr. Wairenga. Commissioner Wilson, question.
Yes, and I just want to take the time to thank Jay for his regular emails and for keeping us in the loop. So thank you very much.
You're welcome.
All right. Thank you, Jay. Ms. West, anything further from your report?
Nope, that's all.
All right. At this time, we do have a closed session, so we'll go ahead and we will close our public session and go into closed session and then report back as appropriate afterwards. our closed session under item 14 on today's agenda. We received information from staff on pending litigation, but took no reportable action. We'll now move to our final item. That's item 15, commissioner comments and proposed future agenda items. Do any commissioners wish to speak on item 15? Hearing none, I would just give a reminder that we currently have a matter on calendar January 26th through 28th. It's in the matter of the city of Fountain Valley. That's an administrative case that the commission will be hearing itself as opposed to an administrative law judge. So again, just a reminder that that's at the end of next month. So we look forward to that. At this point, do we have a motion to adjourn?
Mr. Chair, if I might, on the 250th anniversary of the birth of Ludwig von Beethoven, as I'm sure I was just a boy at a time, but even then we knew it was a momentous moment. Happy holidays, everybody. If you believe in a deity, may she always be with you. Move to adjourn.
Thank you, Commissioner Cardenas.
On behalf of Mr. Brahms, I object. Second the motion.
All right, we have a motion and a second. Ms. Linker.
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Wilson?
Aye.
Chair Maddox?
Aye.
The motion passes.
Merry Christmas.
Thank you, everyone.
Happy holidays.
Happy holidays, everyone. Stay
Happy
safe.
holidays.
See you next month.
Take care, guys.